Hello, my name is Jason Bliss-Wohlers. I'm Coordinator of Unemployment Insurance Programs for the Rhode Island Department of Labor and Training. I've been asked to speak with you today on behalf of the agency to explain some tips, unemployment insurance tips for Rhode Island employers. During the course of today's presentation, we're going to discuss tips for preventing unemployment insurance fraud. I'll present some information on the unemployment insurance separation and data exchange system, which we call UI-SIDES. We'll talk about the wage verification request forms that are often sent out by the department, and we'll give you a brief overview of the central adjudication unit. When we're talking about tips to help prevent and detect unemployment insurance fraud, the most important thing that an employer can do is report all new hires and rehires to the National Directory and the State Directory of New Hires. This is a national system that allows the state the opportunity to know if an employee returns to work, whether it be in Rhode Island or in any other state. It provides additional resources that we can have to gather return to work data that is not normally available from the unemployment insurance claimant. This system allows us to prevent individuals from working and collecting, or for that matter, reduce the benefits paid out to individuals once they return to work. Prompt reporting results in an overall reduction of improper payments, and as such can help to reduce the overall tax burden on the unemployment and the employer in Rhode Island. The second tip that I could provide to help detect and prevent UI fraud and improper payments would be to respond quickly and accurately to the wage verification request forms, Form 720, that I'm going to explain for you later in the presentation. This form helps us to receive accurate, detailed information regarding wages that are earned and help that ensures that benefit payments are made in an accurate and timely manner. It can also help to reduce the size or prevent improper payments. Again, may reduce the tax burden on employers and can assist in the recovery of overpaid benefits. The third tip that I can help provide to employers to help prevent and detect unemployment insurance fraud would be to complete the employee separation notice, Form 425 and 468. Do so in a quick and accurate manner. It's impossible for the department to make an accurate determination without the return of these forms. Oftentimes, the information provided by the unemployment insurance claimant is their interpretation of the separation and not necessarily what happened in the eyes of the employer. So it's critical that we receive these forms back. Providing that information in a prompt manner can ensure that a determination of eligibility is made before the first payment is issued. It's always much easier to prevent an improper payment than recover one that's already been made. And then final point to this notice and this employee separation notice is that this document will help preserve the rights to protest and appeal the claim should the individual be paid and the employer does not agree with that determination. So for closing out the three tips that we might be able to offer to prevent improper payments and unemployment insurance fraud, ultimately is to respond. The most important thing is to respond. You have the information. The department will not get the information unless you provide it to us. So it's critical that you reach out to us and let us know when you have the opportunity to do so. It's our interest and our prerogative to pay benefits to those individuals that are actually entitled, and we want to make sure that we are not paying benefits to individuals that are not entitled. The next topic for discussion in today's presentation is the unemployment insurance separation, information, and data exchange system. It is called UI-SIDES. This is a national system that can be used to communicate separation information between Rhode Island and the employers, the Department of Labor and Training and the employers, and eliminate the traditional paper communication. This system helped create a standard format for responding to UI claims, whether the separation occurred from an employer in Rhode Island or an employer in California, providing the same information, which is very beneficial to larger employers. And it's also made a much more easy process, more user-friendly for the employers in Rhode Island and throughout the country. Rhode Island began participating in UI sides in 2012, April of 2012, and the system was developed as a consortium led by the state of Maryland that had developed quite a successful system. Why, as an employer in Rhode Island, would you be interested in UI sides? Provide a few points that might make it more attractive to you. Unemployment insurance side system is much more secure than the standard mail process. Each individual organization has a unique login and a unique PIN so it ensures that the individual's information, their personal identifiable information, is not exposed to anyone else other than the appropriate employer. UI sides is actually faster than the mailing process. For instance, if a claim was filed today, the employer would be notified at the end of the business day and would be able to respond as early as tomorrow to the separation form. That would make it so that we no longer have to deal with the mailing process. Traditionally, employers have noted that they'll receive the separation notice I mentioned earlier and only have a day or two to respond before the deadline. With the UI side system, the employer has the information, can do the research and reply to the form with plenty of time to spare. UI sides can help reduce costs to the employer. These costs are realized by providing that information quickly. The agency is able to make appropriate decisions in a more expeditious manner, and the decisions will be more timely and more accurate. And as an added benefit, there are no more stamps. And then finally, the big advantage to the UI side system is that this is no longer a form in which an employer is simply filling in a circle to indicate what has happened. They're able to add narrative and provide something simply beyond whether it was a quit or a discharge or a layoff. You can provide your own narrative and put it in your own words to talk about the separation. So again, how is this system, this UI side system, going to help prevent improper payments? It's going to be providing the critical separation information to the department much quicker. We'll be having that in some cases the next day or 2 days later, rather than in some cases a week or more. It's going to be easier for the employer to communicate more clearly. They're going to be able to provide a greater detail about the separation right up front so that we are more able to determine whether or not an issue does in fact exist. And then it's one standardized separation form. So an employer that might have locations in Rhode Island and Connecticut or Massachusetts, if they're participating in UI sites, they're going to be filling out the same document and the same information for each state and not having to worry about which information is needed on Rhode Island's form and which information is needed on the other state's form. It makes life much easier. As with any change or any development, the question is, how much does UI sides cost? US sides does not cost anything to employers in Rhode Island for its use. It's completely free to employers and third-party agents. There are no fees or other requirements. Many employers in the state of Rhode Island are able to connect to the UI side system using a secure web portal and the internet connection they already have in their business. They're able to just simply log on using a user ID and a PIN and complete the forms right away. Larger employers who have higher volumes of unemployment insurance claims may be interested in developing something called a connector, which is a dedicated connection to the host server for the information. This will allow them to easily connect multiple times a day. In this instance, there is a small cost that would be associated with the employer to program and test that direct connection. However, the use of the UI side's e-response system is completely free and is currently operational. Finally, in terms of preventing improper payments, I'd like to speak about the wage verification request forms that we send out. These are the Form 720 that I mentioned earlier. Wage verification request forms is an inquiry by the department to the employer for detailed wage and earnings information for a particular period of time. Generally, these requests for information are made because the information is not readily available at the time the claim is filed. But in some cases, they can be an instance of a hit on a cross-match report or a tip to the fraud hotline. I want to make sure that it's clear that the completion or the request, the wage verification request, is not necessarily an indicator that someone is committing fraud, although a fraud case may result from the information being provided to the department. The wage verification form is a rather complex form, so the next few slides will give you the opportunity to take a look at that, and I'll help explain it. The upper part of the wage verification form is the demographic information for both the employer and the claimant. This will come pre-populated. You won't have to do anything with this section on the form, which you see before you. It's just simply going to tell you who we're looking for information about and when we made that request. The meat of the form, the body, if you will, of the wage verification form is where the employer is going to be entering the detailed earnings information. You can see it on the slide in front of you. We're going to be providing you with the calendar week ending dates. We're going to be asking for the wages reported. It's important to note that the wage request form is going to be asking wages on a Sunday to Saturday weekly basis. It's important that it's reported in this manner because that's the manner in which unemployment insurance benefits are paid. So we need to compare for the same identical periods. In some cases, it may not comply with the current payroll process of your business, and it can be difficult to determine those wages for that period, but it is very important that you do so. For each week, each ending date that we have requested on the form, you're going to be asked to provide the gross wages earned, that's before taxes. You're going to be asked what kind of wages are available, and you're going to be asking if there is any additional pay or days missed. Complete that as best of your ability, and we'll be able to make more accurate decisions. And then the final section of the wage verification form is simply the department's request for the current status of the employee and for the certification, the signature for the employer certifying that the information is accurate. You're going to be entering the day that the employee started. You'll be entering the day that the last day that the employee worked for the periods requested, and then if the employee has separated for some reason, the reason that they're no longer employed there. And then you simply sign and date it and provide your telephone number. This form is very important for us because it allows us to determine, in many cases, whether or not an individual has, in some way, shape, or form, collected benefits while they were working and not reported those earnings. In many cases, it's just a check, and we are able to confirm that the individual has in fact complied with the law, but in some cases we're able to detect when they have not. That's the completion of the section of my presentation today on tips for preventing fraud and or improper payments. Now I'd like to take a few minutes to talk to you about the Central Adjudication Unit. In general, the Central Adjudication Unit is the part of the agency that will be addressing and resolving disputed claims. So if an employee is separated for a reason other than a layoff, an adjudicator within our Central Adjudication Unit would be gathering facts and providing a determination as to whether or not that individual is entitled to benefits. When we go through this process, the individual files a claim for benefits, and they record the reason why they are no longer working. If it's for any reason other than a lack of work, so for example, a quit, a discharge, or some sort of labor dispute, the adjudication process begins. Once this process begins, we submit a form to the employer. It's the employee separation notice, and we ask the employer to respond to that form to confirm that separation reason. If those information is received and it is not, in fact, an issue that we must investigate, telephone interviews are conducted between all parties. The Rhode Island general laws require that employers return the employee separation notice to have standing in any sort of disputed claim. This means that if you wish to receive a copy of the determination, if you wish to appeal that determination, that you must respond to these forms. So it's critical that you do so. You have 7 working days to complete those forms and return them. That's a big advantage why with the UI Sides program is that you do only have 7 working days, so if you get that form faster, you'll be able to complete it and return it in a timely manner. When it comes to the day of the unemployment insurance CAU appointment, the department will call the claimant and will call the employer to obtain the facts relating to the separation issue. Once those facts are obtained, a decision will be rendered to allow or deny the person benefits. Those decisions are based on the facts obtained during the telephone interview, the unemployment insurance law, and any documentation or evidence that is provided by the employer or the claimant relating to the issue at hand. When the adjudicator calls to speak with the employer, they're going to be asking for a representative that is authorized to speak on behalf of the employer. They may also ask to speak with anyone that has direct first-hand knowledge of the situation that led to the individual's separation. If the authorized representative or the individual with the first-hand knowledge is unavailable, the adjudicator will allow a 48-hour window for the individual to return call and make a statement. If for some reason the department is unable to obtain a statement, a decision will be rendered based on the information that is available at the time. As an important side note about disqualifications from unemployment insurance benefits, individuals who are denied benefits, if they do return to work and are employed for at least 8 weeks and earn at least the weekly benefit rate in each of those weeks, they will be considered to have overcome any disqualification. Subsequently, if an individual has overcome a disqualification and is then unemployed for non-disqualifying circumstances, they could be allowed to collect on the existing claim. I'm now going to take some time to talk about the various sections of the Unemployment Insurance Code that are relevant to many of the adjudication cases that the employers deal with and the agency deals with on a regular basis. We're going to begin talking about Section 2844.18 of the Rhode Island Employment Security Law, which is discharge for misconduct. That section of law provides that an individual who is discharged from a position will be denied benefits if there is evidence of deliberate misconduct in connection with the work at the point of separation. In these scenarios or in these cases, the burden of proof rests with the employer to establish that the misconduct was in fact deliberate and was disqualifying. In many cases, simple negligence, an inability to perform a job, or good faith errors in judgment are not disqualifying circumstances. For everyone's understanding, misconduct is defined as a deliberate conduct in willful disregard of the employing unit's interests, or a violation of a reasonable and uniformly enforced rule or policy of the employer, provided that such violation is not shown to be the result of the employee's incompetence. Some basic questions that you'll be hearing or dealing with when it comes to an adjudication interview for discharge. We're going to want to know the specific reasons for the discharge, including when it occurred. If the discharge was due to a policy violation, we're going to want to know if that's a written policy and have verification that the individual was aware of that policy. In other words, did they know what they were doing was wrong? And also, there's going to be interested to find out whether or not this was a repeat offense. If this is a repeated offense, we're going to want to know the prior dates in which this incidents occurred. We're also going to be wanting to know whether or not there were any warnings that were issued and whether or not copies of any of the documentation is available. All of these things would be counted as the documentation to support your case that I mentioned earlier in the presentation. If an individual resigns from employment, or as many people call it, quits a job, they would need to have good cause for doing so, or they would be ineligible for benefits. In the situation of a resignation or a voluntary quit, the burden of proof in this case rests with the employee or the unemployment insurance claimant to show that the job was not suitable or that there was no other alternative other than to leave the job. It's also important to note for employers that are temporary agencies that they are required to have a signed contract with an employee requiring contact following the completion of an assignment for them to have been considered to have voluntarily quit. Some basic questions or factors that you should be prepared for when you're being interviewed about a voluntary quit would be, did the individual give notice? What was the reason that the individual stated for leaving the job? If they left for an issue related to the work, did they make any attempts to resolve that issue? For instance, did they ask for a leave of absence? Did they ask for a change of hours? Did they ask to be relocated to another facility or have some sort of transfer? The next topic that we usually get a lot of questions about from the employer community is something called a refusal of suitable work. That's section 284420 of the Rhode Island General Laws. And that section states in summary that if an individual failing without good cause to accept suitable work when offered shall become ineligible for benefits for the week in which the failure occurs. In general, I'm asked many times, well, I've offered an individual a job and they didn't accept that job, and how can you continue to allow them to collect benefits? It's a reasonable question. I certainly understand why it's being asked. It's because of this section of law that I just quoted. In general, the work must be suitable, and that means that the individual must be reasonably fitted to perform that job. For someone like myself with a college degree in political science, you couldn't ask me to do brain surgery. That wouldn't be reasonably fitted. The position also needs to be located in a reasonable distance for his or her residence or the last place of work, and it must not be detrimental to his or her health, safety, or morals. If you do have a concern about a refusal of suitable work, some of the questions you may be asked and some answers that you may be prepared to respond with revolve around these set of instances. A job is not considered to be suitable if the position is vacant due to a strike or some other labor dispute, if the wages, hours, or conditions of work are substantially less favorable to the employee than the prevailing wages or conditions of work for similar work in the area, and if, as a condition of hiring, a person or individual is required to join a union, resign from a union or other labor organization, or refrain from joining one of those organizations. So some basic questions that you'll receive when dealing with suitable work issues is, was there a bona fide offer of work made? So generally, was this a real offer of work? Did they have specifics about the job? Did they know what they were going to be doing and when they were to start? Was the offer successfully conveyed to an individual? Unfortunately, just leaving a voice message on someone's voicemail does not mean that the offer of work was successfully conveyed. Many times we would look for that offer of work to be made in writing or via email or something along those lines. So we're going to want a verifiable method for having offered the work. What was the date that the job was offered? What was the job title of the job that was offered? And it's also going to be important for us to know the wage, the hours, and the location of the job that was offered. Another question that I often receive is relating to the availability for work. Many employers don't understand the basis for any sort of individual being able for work, unavailable for work, or unable to work. And the law, section 284412, indicates that an individual in receipt of unemployment benefits must be able, available, and actively seeking full-time work for each week benefits are requested. They must also respond when duly called for work through the employment office. And finally, they must make an active, independent search for suitable work for each week. And again, there we see suitable work, so it must be work that they're capable of doing. Unfortunately, we have, or I should say, these are one-party issues when we're dealing with availability for work, so oftentimes we take the employer's statement because there are no other individuals that are interested parties to that issue. After the determination has been issued on the disputed claim, a decision will be made and mailed to the employer and to the claimant. Either party has the right to appeal any decision that is rendered by the department. Directions for filing an appeal are listed on the document that you will receive. The appeal must be filed in writing within 15 calendar days of the mailing date of the decision. Those are calendar days, which is different from the employer separation reform, which is working days. And an individual must do so in writing. They must appeal a decision in writing. So that applies for the employer as well. So you can submit an appeal to the department by mail, by fax, or actually on the internet. We're able to do it on the internet now through our website. In closing, 3 key factors in just about any adjudication process would be the date of the separation, the specific reason for the separation, and documentation, including statements, to support any other sort of assertion that may be made in terms of the decision. The information today that is presented is certainly voluminous and can generate a lot of questions. If you have questions, the department is available to help you answer those questions. You may contact us at the dedicated employer line. That telephone number is 401-243-9137. If no one is available, you may leave a message and we'll return your call. You may also get further information about our program on our website. You can reach that website at www.dlt.ri.gov. You'll need to select the Unemployment Insurance tab and then the Employer Information tab. Thank you for watching and have a great day.